Hello guys, are you well? Okay, before we start, some house rules. Normally when I present, I want the audience to join me in the presentation, to ask questions, to make statements, to start debates, but not today. I was so delighted, now on my phone, they said, please do a presentation for us. I'm in. And then I saw 20 minutes. So I'm sorry, I'm going to go through it. This is not my style. Normally I present for hours at end, but please enjoy, be patient with me. So today, my mandate for today is to assist you with your preparation for CSOS dispute resolution process. It's a very short topic. Albeit that I was provided 20 minutes, I'm going to keep you here for 2. There's only one statement that I want to make. Phone me. Okay, on a serious note, we've got the CSOS. Why is this topic still relevant? Before I answer my question, I just quickly want to gauge the audience. Trustees, anybody who's trustees here? Pay trustee? Okay. Managing agents. And the rest, I see there's some very knowledgeable attorneys sitting there. If you need anything, go to them. No. Okay, so it's good that you know, because we had this focus session yesterday on the duties and the mandate of a managing agent. Now, as you know, you are a jack of all trades. You need to know how to run with this process. But do you actually know the process? And the answer is no, because you haven't embraced the CSOS process. There's this negativity towards CSOS, which I don't mind. No? Like I'll go to court for you. But there's this mechanism. One needs to be mindful of the monetary amounts that you pay to us. There's this simple process that you need to use, embrace it. So for today, what we want to do is I cannot prepare you for a trial matter. That's within my expertise. There's certain attorneys that get admitted, but they cannot go to court. So I'm not expecting you to become a litigant. What I'm going to try and achieve for today is just go back to basics. In the words of Nelson Mandela, knowledge is the most powerful tool which you can use to change the world. And this is what I want you to do. Embrace the process, understand the process from the building blocks up. And if you can do that, you can serve your clients. And I'm in practice. So I reached out to the CSOS to come and explain actually what's going on there. So today, the Honourable Mr. Abraham Masilo is going to join us, and he's going to explain the process for us. So we're going to look at the dispute resolution process. We're going to touch on certain case law, and if there's any time, I'm going to take you through some practical advice. So let's start off in the beginning. The CSOS. It's not just that logo. It's not just a few people attending seminars. It is a statutory body created by statute. And their mandate comes from the Sectional Title Schemes Management Act and the Community Scheme Ombud Services Act. So what is a statutory body? Well, it's simple. You go read the statute and you'll understand their mandate. They can't just act as they wish, which is a very simple and knowledgeable tool for you. If you don't understand it, there's a piece of legislation that you can go through and you can read up on it. And that's the mandate. So when you look at CSOS, the 4 main functions is to provide training, which they do very well. I think we can applaud CSOS for actually the training that they provide to everybody. Angeline? To regulate, monitor, and control the quality of all sectional title schemes. That they do. To take custody of, preserve, and provide public access to scheme governance documents. That they do. But the biggest thing for me is to develop and provide a dispute resolution mechanism for all community schemes. This is why we're here today. There is that mechanism for you guys to use. Embrace it and use it. So, in my preparation, I went on and the newly developed website, there's the vision of CSOS, is to promote harmonious community schemes by providing regulation, education, and accessible dispute resolution services to all relevant stakeholders. So, you've seen, and I understand the obstructiveness from the industry. This was a body that was created. Everybody had to find their feet. But I think through time and through management, they found their feet. So let us embrace the process of CSOS and let us approach CSOS. So if I can have Mr. Masilo on stage with me to come and explain to you the practical aspect of submitting a claim and the claim process for your education. Thank you.
Thank you, Rudi. You can have a seat here. This is forward. Thank you, Rudi. I think you've said it all. I don't need to say anything. I'm also going to make just one statement. Call me. Yeah. Please, will do. The most important flow of your application as it's received by CSOS, it has to go through all these 4 stages. These are the most critical stages. As soon as we receive the submissions, we then have to do what we call an assessment. Is it fine? Yeah. Thank you. Then we do an assessment, and from assessment, we deal with conciliation, and then investigation and adjudication. And I will take you through each one of them. The most important thing in an application form, we're looking at ensuring that the statutory application form is submitted to us. That form is designed so that we can know the jurisdiction. We can know the jurisdiction also in terms of the court, the area where in an event of an appeal. I was just now at the other session wherein they were dealing with appeals, so that you know where to lodge your appeal, which jurisdiction. And also the form has to be signed. It has to be in English. It has to be as simple as possible in terms of its explanation. And furthermore, you will note that we are saying there is no longer a need to pay for fees. And therefore, we will then appoint an adjudicator for you, as opposed to what the current legislation was saying, that if you pay a particular fee, then you have a right to ask for a particular adjudicator. But now, because of the turnaround times that we want to make sure that we finalize these matters as soon as possible, we want to ensure that we allocate these matters to those that are available, in particular those adjudicators as well as conciliators. Quickly, in the form, you need to make sure that all the areas are fully completed. The parties must be properly cited. Community schemes must provide, the province to make sure that we know where to lodge this matter in an event of enforcement or an appeal. We want the respondent details. This is a critical area because if you don't give us the respondent details, how are we going to serve the very person that you want to bring to us in order to account to your allegations? So it is important that we get those details. Obviously, and then we will then register and then allocate an application, a reference number. Now, also what is critical is that you need to understand that if you are an executive committee, an association, a managing agent, and so on, we require you to make sure that you also, over and above that, you submit a resolution. Without the resolution, you are not authorized to deal with any matter that comes before us. So it is important that you know that you need to do that. And finally, on this one, I want to also emphasize that any matter that relates to a decision, you have to bring to us within 60 days. Failure to do that within 60 days, we will then reject your matter. However, at least the legislation has afforded us an opportunity to ensure that you can then submit to us a condonation wherein we may then consider and then be able to deal with your matter. But that condonation, clearly it has to be within reasonable time. Because if it outside of a reasonable time, you are bound to fail. And this is not what we want. However, you would note that with recent cases that in terms of the appeal, the 30-day period in terms of the appeal, that the courts are reluctant to give you that condonation, and you will not get it if you fail to submit your appeal within 30 days in terms of our legislation. Regarding the assessment, we're looking at the jurisdiction in terms of our Section 39, whether the matter falls within our ambit. If it falls outside of our ambit, which we have found that the most applicants tend not to understand when we indicate to them that we are unfortunately not able to deal with certain matters because we are a creature of statute, to an extent that then they will then insist that we accept that matter. There's also an issue pertaining to internal remedies. It is important that parties must deal with these issues within that particular scheme. Because if you don't deal with the issues within your scheme and you bring it to us without trying to resolve this matter, we will be inundated with a lot of matters that ordinarily would have been resolved within your scheme. So as managing agents, as trustees, please be cognizant of those queries when they come to you, because in most instances we find that the issue is the applicant will say, I have tried to speak to the managing agent, I've tried to speak to the trustees, and there is no assistance whatsoever. And we are saying, please try and assist them so that we can avoid coming to CSOS unnecessarily. And again, if a matter has been adjudicated upon, we'll certainly not deal with it because you are now bringing an appeal via backdoor. So those are some of the issues that we look at when we do our assessments. And obviously, if we have the view that the matter is also currently in court, what we'll do is we will then not take that matter because you can't have two matters adjudicated at the same time in different forums. Subsequent to the assessment, the matter might go direct to adjudication. However, in terms of our process, it must start at conciliation. It is important that you attend these conciliations. We have seen a trend wherein some community schemes will say, I don't want to attend your conciliation if it's a matter by one of the owners. And it doesn't help because you want somebody to make a decision for you, whereas you need to go back and then discuss those issues, have a neighborly relationship with the owners to an extent that it brings harmony. If you would note what Rudi said earlier, that one of the most important mandate of us is to ensure that there is harmony within this community scheme. So it is important that you attend these conciliations. And remember, we're dealing with feelings here, wherein people come to us very irate, to an extent that we need to afford them that opportunity to talk, to air their views. And I think it is important that there must be, that decorum and conjugality amongst, parties that are in that conciliation, because it is important to listen to one another so that you find common ground. So it is important that you attend these conciliations. It is better to an extent that you make an agreement that is suitable for all parties that are in the conciliation, as opposed to have this matter being adjudicated to by a third, somebody who does not perhaps maybe even understand where you guys are coming from, doesn't understand even your relationship to an extent that then he's going to make a decision for you, whereas you had this opportunity as within conciliation that you would have at least resolved that matter yourself. And once the parties settle or agree to settle, then we will draft the settlement agreement. However, we will have a clause in the settlement agreement that in an event that either of the party defaults, then that settlement agreement may be immediately made an order of the adjudicator. So you don't need to come back to us. I know that there are some divergent way of dealing with this, where in other jurisdiction, in other regions, wherein you will then have to still apply again for you to get that adjudication order once you have the settlement agreement, as opposed to the other regions wherein we just receive that because you already have the clause. The clause is inserted, is there. We might as well just do the adjudication order and give you your adjudication order.
Sorry, Mr. Masilo, I just want to touch on this.
Yes, Rudi.
I've had a few of my clients coming to me and saying, we've lost the conciliation process. Alternatively, I've had clients that prepare for the conciliation process as it is preparing for trial. Yeah. Can you please explain the intention behind conciliation?
Yeah, I think
that is not an argumentative thing. It's not. It should be there for the intention to try and get common ground.
Indeed.
You can't lose conciliation. There is no such thing.
Yeah, there is indeed no such thing. I think the key point there, or the key word there, is the conciliator is a facilitator. The conciliator assists parties to come to a certain conclusion. And the conciliator does not make a decision. So, and we've had those instances. And I think it's a question of, using certain words incorrectly and so on. So, but at the end of the day, the conciliator facilitates the process, assists the parties to come to a common ground. And once the parties agree, then a settlement agreement is drafted. And then subsequent to that, then we finalize the matter. So, as I said, once in an event that conciliation does not succeed, then the matter then goes to an investigation and adjudication. You will note that the adjudicators, they've got investigative powers in terms of Section 51 of the CSOS legislation. And those investigative powers are saying to the adjudicator, you read the documents. If you are of the view that you still need some more information, you can still call on parties to come and explain further. And it is for this reason that what we did, especially during or since the advent of COVID, what we did is we then introduced what we call final submissions. What we mean there is that we are saying, yes, we have received your Section 43, that is, your application. Yes, we have received your responses, but we are still affording you another opportunity to come and explain yourself, to say, I think maybe I might have missed something, especially after receiving the responses, and I'm of the view that my matter should actually end in this manner. And that's what you are telling the adjudicator, and the adjudicator will be able to understand where you're coming from, what are your expectations, and be able to deal with the matter. And remember, the adjudicators somehow will meromutu enter the fray, and that is the reason why, Rudi, you don't find attorneys representing clients at CSOS.
You're chased away.
No, not at all. What we're saying is that we want to allow, parties, to feel free to be able to deal with these matters, and to an extent that the adjudicator will assist. How will the adjudicator assist? Being fair, obviously, will just apply the legal principles that are applicable at that time, or in terms of the matter before the adjudicator. And obviously, once we receive the final submissions, then the matter then sits before the adjudicator, who will either decide. One may decide to call the parties to come and present the case, wherein you will then have a face-to-face adjudication, or the adjudicator will be able to finalize the matter based on the papers that are before the adjudicator. And that is the discretion that is for the adjudicator to make. The adjudicator is the one who makes that final decision in terms of that issue. And obviously, I spoke about the appeal that, you need to appeal in an event that you're not happy with the adjudication order. You need to appeal within 30 days. And I am telling you now that there are recent judgments that are saying that the courts are reluctant to grant an extension. So the sooner you come back to us and you appeal in court, the better, so that we can be able to assist you and make sure that, we guide you what to do. This is where then Rudi comes in then. When there's that appeal, then, wherein he will be able to assist you further in terms of the divergence ways of obviously appealing. There are three. There's one for the Western Cape, similar to the KZN, but the one in Gauteng is completely different from that. However, we are working on it to make sure that we have a uniform way of appealing these adjudication orders. The process flow, I'm going to just run through this one quickly so that I give back to Rudi to complete his presentation. The entire lifespan of a matter at CSOS, it's 90 days. That matter must, irrespective of it goes to adjudication, it goes to conciliation, or it is resolved prior to that, but we are saying the entire lifespan, and I think you would have seen the changes that we've introduced. I think the Chief of VAT came with new processes, introduced new processes to say we need to be responsive. We need to make sure that we resolve these matters as speedily as possible. And I think we have actually shown that we have improved a great deal in terms of that. You have seen that these matters are really disposed of within a reasonable time, and in most instances, even lesser than the 90-day that we have put out there to say we will resolve your matters within that 90 days. And it comprises of a whole range of the entire process flow, which consists of the registration within 3 days. Once you lodge now, you'll immediately receive, your acknowledgement. And then we ensure that we assess your matter. And when we say we assess, it's not only about jurisdiction. We also go in terms of ensuring that we exchange the documents. In court, we'll say we'll exchange the pleadings, but we exchange the documents wherein we do our Section 43, and then we move on to Section 44, and then we come back and say the matter is now ripe, is ready for the conciliator or either the adjudicator to finalize that matter. So that is our process flow. In terms of that, we serve all parties concerned. You'll note that when we serve your Section 43 and say, here are allegations by the applicant, we expect you to come back to us within 7 days. However, we have shortened the period to 5 days when it goes back now to the applicant. Remember, it's your matter. You are conversant with your matter. You understand what is happening with your matter. We don't expect you to take another 14 days or 30 days really to respond to those, to the responses to the allegations, because it is your matter. You must be ready. You want the matter to be finalized, and we want to make sure that, we cover the entire 90 period as I have indicated. The conciliation, as soon as the matter sits on the table of the conciliator, within 14 days, we expect the conciliator to have done and completed that conciliation. Similarly with the adjudicator, as soon as the matter sits on the table of the adjudicator, we expect the adjudicator to dispose of that matter within 20 days. Reason being that, remember, there is that Section 51, investigative processes that the adjudicator may invoke. And under those circumstances, then you must give the adjudicator that opportunity to be able to exchange those emails and so forth. What we've done, also we've introduced what we call a quality assurance, and that's the reason why in most instances, especially now recently, even the appeals, most of them do not succeed. Because we have done our homework now. We have ensured that there is that quality assurance layer that assists to make sure that the adjudication orders are of quality and are of sound and quality and legally, you can interpret them and they are legally sound. Because if they are not, this is where we would then have challenges with regard to unnecessary appeals and so on. But remember, an appeal is a right to any person who feels is not happy with the order, you have a right to an appeal. However, we are saying we have introduced that leg, and you've seen, I think, our adjudication orders are of a high standard. And this is where I think I want to leave it for you, Rudi, so that you can then proceed with, the court decisions now. Once we have issued those adjudication orders, or we have converted those conciliations into, or settlement agreements into adjudication orders. Thank you, Rudi. You can proceed and finalize it. Thank you.
Mr. Masilo, thank you so much. We can have a round of applause for him. So I see we're running out of time, so I'm not going to be long. So why have we explained this process to you? So it's a very difficult topic for an attorney in practice to tell you this. It is because the court is starting to motivate that you proceed to CSOS. We've got 2 judgments. You can go read them. It's the Saranto matter and the Heathrow matter. Both of these judgments refers to the ambit of CSOS. Our court system these days wants to motivate people where there's a dispute mechanism process to first exhaust that process. The Heathrow matter was an urgent application, and it came before the Honourable Judge Binns Ward. He loves writing great judgments. And he took this matter, it's a simple, urgent application, and he could have disposed of it by saying, it's not urgent, the matter is dismissed. But what he did is he explained the process, and he set out the rules. And he said, where you have the CSOS, an inexpensive process for the schemes to adopt, you need to approach CSOS. In that matter, he went on so far as to make a punitive cost order against the scheme by approaching the court and not the CSOF. So be very careful when advising your clients, let us go see an attorney. I didn't say that. But it is. Embrace it, adopt it, understand the process. I'll be there at the end. I will still be there. If you're unhappy, we can appeal. But guys, you need to approach CSOS first. It's going to change. Look, I'm not saying that the court does not have jurisdiction. But what they're trending to do is dispose of matters because you did not approach CSOS.